So this is the 9th April editorials of the Hindu. So the first one is a new methodology with some issues. It's written by G.S. Manna, who is the professor of Institute of Human Development at New Delhi, and he was earlier the Director General of the Central Statistics Office (CSO) and the National Sample Survey Office (NSSO), and a member of the National Statistical Statistical Commission. Okay, a new methodology with some issues. The National Sample Survey Office (NSS), that is NSS. The NSS office released the key results of the Household Consumption Expenditure Survey HCES 2022-3 in late February. These primarily include all India estimates of the average household monthly per capita consumption expenditure for rural and urban areas. Its distribution by broad item groups for food and non-food categories. The variation in the average MPCE, that is uh, MPCE क्या है? Monthly per capita consumption expenditure. Okay, the variation in MPCE कहाँ गया यार? The variation in the average MPCE, monthly per capita consumption and expenditure. So the variation in the average MPCE of households with different standards of living, and the trend in the composition of MPCE since the 1990 to 2000 survey. So far as the state level estimates are concerned, the fact sheet gives only estimates of average MPCE, total of food and non-food items for each state and union territory for rural and urban areas. As the earlier available results pertain to 2011 and 12, the latest results have bridged the data vacuum of more than a decade on an important subject that also goes into the compilation of poverty estimates. While the methodology for the HCES, that is Household Consumption Expenditure Survey, while the methodology for the HCES is more refined now, there are still challenges that need to be addressed. This will ensure that apart from producing much firmer estimates of the average MPCE, that is monthly per capita consumption and expenditure. This will ensure that apart from producing much firmer estimates of the average MPCE, the new series has an inbuilt mechanism to maintain comparability of the current estimates with those of the earlier quinquennial series available from 1972 to 73 to 2011 and 12. Changes and implications. One change in the new household consumption and expenditure survey, one change in the new HCS is the updated item coverage, which has been done keeping in view the latest consumption behavior. Another significant change is the splitting of the single questionnaire into three parts covering food items, consumable and service items, and durable goods. The three questionnaires have been used at random in a selected household during three separate monthly visits, contrary to the past when the team would visit a household just once. Using the single questionnaire during the one visit often resulted in long interviews. As a result, respondents were fatigued and there was a possibility of under-reporting consumption expenditure, particularly in respect of items like durable goods, which were placed towards the end of the questionnaire. While the latest change will help us derive more reliable estimates of the average MPCE, monthly per capita consumption and expenditure, we are also now unable to compare the current estimates of the average MPCE and the share of poor that may be derived from it based on the survey data with the estimates of the past, given the likelihood of underreporting of household consumption expenditure in the previous surveys. A third change is in the method of stratification of villages and urban blocks for the purpose of sampling. Third change is in the method of stratification of villages and urban blocks for the purpose of sampling. While in HCES 2011-12, every district was considered as a basic stratum for rural and urban areas. Every district was considered as a basic stratum for rural and urban areas. The new HCES considers a state or UT as the basic stratum, while every district with some minimum sample allocation got represented in both the rural and urban samples of 2011 and 12 survey. The new HCES does not ensure the same. Such a change does not affect the generation of state-wise estimates. There is also a change in stratification of households. All the households of a selected village oblique urban block are classified into three groups depending on a criterion. The criterion in rural areas is possession of land, and in urban areas it is possession of four-wheeler cars for non-commercial use on the date of the survey. The total sample of 18 households with proportional representation from the three groups have been selected. Given that the proportion of urban households possessing four-wheelers is as low as 6% in states like Andhra Pradesh, Bihar, and West Bengal, as per the National Family Health Survey 5 (NFHS 5). Adequate number of rich households in the sample may not get insured in such states as intended. It is worthwhile to note that the said stratification in the HCES 2011 and 12 was based on the average MPCE of the households, with the top 10%, middle 60%, and bottom 30% forming the three strata, and a sample of 2, 4, and 2 households respectively was allotted to these strata. Okay, methodological issues now. The splitting of the questionnaire and visiting a sample household thrice now have led to non-comparability of the current estimates with those of the past. Okay, so since earlier there was different method, now the method has been totally changed, so it would be difficult to compare present data with that of earlier data. So the splitting of the questionnaire and visiting a sample household thrice now have led to non-comparability of the current estimates with those of the past, although the current estimates appear to be much firmer ones. One way to address this issue is to replicate the traditional approach of one schedule with a one-time visit to household in an independent random sample of households to be drawn from the same villages and urban blocks of the at least one of the panels for which the fieldwork is yet to commence. In this context, it is important to note that the sample in the new HCES for a year is in the form of 10 panels, each comprising consecutive 3 months, with an equal number of sample villages urban blocks allotted to each panel. This add-on module will facilitate generation of two independent estimates of the average MPCE and other associated correlates based on the current approach vis-a-vis the earlier one. This information will be useful to study the extent of divergence between the two alternative estimates of MPCE and build a comparable series. Further, to ensure adequate representation of rich households, it will be worthwhile to develop a frame of such households based on administrative data and a random sample of a households drawn from this frame for inquiry on consumption expenditure of a rich households through a dedicated survey. This database, in conjunction with those from the HCES, will be useful to derive an improved distribution of households by their average MPCE. Okay, the next one is Indian Aviation, a case of air safety at a discount. It is written by Captain Mohan Ranganathan. He is a former airline instructor pilot and aviation safety advisor. He is also a former member of Civil Aviation Safety Advisory Council. Indian Aviation, a case of air safety at a discount. The oft-repeated statements by the Union Minister for Civil Aviation, Jyotiraditya Scindia, and the Directorate General of Civil Aviation (DGCA) that first, safety is paramount, and second, India has one of the fastest growing aviation sectors, are ones that are at complete variance with each other when there are two very serious safety issues staring at aviation in India. In June 2023, the minister had written to the Kerala government implying that the safety of passengers was being gravely compromised due to the non-provision of the runway and safety area at Kozhikode's Karipur airport. The provision of this safety feature was explicitly recommended by the Aircraft Accident Investigation Bureau. After its investigation and recommendation, following an air crash at the airport on August 7, 2020. The minister said that the ministry would be left with no choice but to proceed with the necessary action of curtailing the runway length for safe aircraft operations at the Calicut airport from 1/8/2023 unless the land is handed over to AAI immediately, Airports Authority of India. We are now in April 2024 and just a couple of weeks and months away from the southwest monsoon and later the northeast monsoon, yet no land has been made available and flights continue at the airport without restrictions. In January 2024, Mr. Sindhia in a post on X had said, after in-depth analysis of pilot rosters, fatigue-related reports and direct feedback from pilots, we have introduced revised FDTL regulations, flight duty time limitations that include increased rest periods, redefining night duty, and regular fatigue reports to be shared by airlines. The deadline for their implementation was June 1, 2024, but airline owners in India went rushing to the ministry and DGCA stating that they would need additional crew to meet these requirements and hence flights would need to be curtailed. In March 2024, the DGCA deferred the deadline of June 1 indefinitely. All this all this raises the question, is safety paramount for the minister and the DGCA, or are the commercial requirements of airlines taking priority over passenger safety? Or are the commercial requirements of airlines taking priority over passenger safety? Going by the actions so far, air passengers should be aware that they are flying purely on a horoscope. Should be aware that they are flying purely on a horoscope. The authorities and airlines are clueless on safety standards. Systems overseas. Why has the International Civil Aviation Organization introduced the Fatigue Risk Management System (FRMS) as a mandatory requirement? Is it it is with good reason. The study of various accidents and serious incidents due to fatigue has shown sleep deprivation and impaired reaction times to be identified as a major cause. Countries such as Japan, Singapore, and the United Kingdom lay a lot of stress on fatigue management and also rest periods for flight crew. They follow a system where pilots get 2 days off every week to rest their body clock and recover from cumulative fatigue. For long haul flights, they are provided augmented rest on return to their home base. The common refrain one hears is that pilots are overpaid for the work they do, when even senior executives in airlines earn less. In 1985, when I was part of the central executive of the Indian Commercial Pilot Association, this was the argument put forth by the Director of Personnel and Director of Finance of the airline, that is Indian Airlines, to deny pilots an increase in emoluments. I highlighted the huge difference between the working conditions of pilots and ground personnel. Pilots got just 30 days of annual leave and a day off every week due to FDTL limits. Contrast this with ground personnel who got weekends off, which is 104 days, all public holidays, and their annual leave. I told the IA, that is Indian Airlines Management, that pilots would forego the increase and would also work the same number of days that ground personnel did in office. People fail to understand that a pilot is a human being and not a machine. People fail to understand that a pilot is a human being and not a machine. He or she needs time with their family too. Two, day, two, day, 2 days off in a week is a must to be with family. The human factor is distant. Airline rosters never take the human factor in account. The limits laid down by the DGCA do not mean that a good airline system cannot utilize pilots to a lesser number of flight time and duty hours. When airlines place orders for aircraft, airlines owners go by the DGCA civil aviation requirements. For scheduled transport, which lays down the minimum crew requirements, it is compared with the FDTL CAR. The requirement of crew would be more than double depending on the type of operations. So, does the DGCA monitor crew number based on the requirements in FDTL CAR? The answer is no. After all, it would affect the news headlines grabbing effect of a large aircraft order and downplay the hype around the country being the fastest growing and downplay the hype around the country being the fastest growing in aviation. Financial stress can have a very adverse result on a pilot. The United States National Transportation Safety Board report on a Silk Air crash on a silk air crash on December 19, 1997, which claimed 104 lives, identified the issue of captains' gambling debts and pilot suicide. In the Egyptian crash on October 31st, 1999, too, there was 1999 too, there were similar findings. I refer to two accidents as, in addition to pilot fatigue, the authorities in India do not pay heed to the dangers of financial stress. It is shocking to have reports that the co-pilots of Vistara, the only flourishing airline under the Tatas, were given an ultimatum to sign their new pay structure contract by the end of the day or else lose their command position when Vistara is eventually merged with Air India. It would have meant a drop in income by almost 50% for a young pilot who has invested over a crore of rupees to obtain his license to fly and who is up to the neck paying equated monthly installments towards the loan. Does Vistara's management consider it safe to subject a young mind to such thoughtless pressure? Will the flight be safe when the pilot's mind is worrying about his loan? The Tatas are known to care for the welfare of their employees. It is surprising, therefore, that when it is an issue that concerns pilots, the issue takes a back seat. It is surprising that when it is an issue that concerns pilot, the issue takes a back seat. Why are airlines looking at co pilots as only an occupant on the flight deck? They are the airline's future captains and are a long term investment in an airline's growth. The human resource departments of airlines have failed. Airlines are bound to lose even their captains who will move to an airline that operates with human values. Airline owners may call this illegal poaching, but in a country where lawmakers switch sides for handouts, blaming pilots is unfair. After all, these airline friendly rules and recommendations made by DGCA cannot be the result of a mere over the table approach. The electoral bond issue is a tale that has exposed many, and aviation is not an exception to this. Some solutions. Now, talk about solutions. To meet pilot shortage, there is an immediate solution. India should adopt to the ICAO Annex, that is International Civil Aviation Organization Annex 1 standard, which allows a member state to recognize another ICAO license and issue an Indian license on the basis of only an air law examination and a class 1 medical. There will be hundreds of qualified and experienced Indian captains working abroad who will return to India if the hurdles that the corrupt system uses to prevent them from returning are demolished. If the hurdles that the corrupt system uses to prevent them from returning are demolished, the DGCA, in collusion with airlines management pilots, has a rule that makes it mandatory for an instructor or an examiner to be an active pilot. However, they will accept a retired pilot working in training center abroad to carry out the mandatory checks on Indian pilots. Retired pilots can be utilized for simulator training. Such as STEP will also release a large number of trained pilots for active flying. Hanging on to the rules that were drafted in 1937 and the system that has large scale corruption will never result in Indian aviation shining. As for the Tatas, if they want to make their merger of four airlines result in a trouble free world class airline system, they need to introspect deeply over the importance of human factor in aviation. Finding excuses such as air traffic control delays for large scale flight disruption, as Vistara cited, will cut no ice. It will cut no ice. It is transparency and building brand loyalty that will help them regain their past glory in aviation. It is transparency and building brand loyalty that will help them regain their past glory in aviation. Then in the text and context page there is an article, why have madrasas been in the spotlight in Uttar Pradesh? Okay, why did the Supreme Court stay a ruling of Allahabad High Court on UP Board of Madrasa Education Act 2004? What was the aftermath of the UP government survey on madrasas? Let's give it a read. The story so far. This past week, the Supreme Court stayed a ruling of the Allahabad High Court on the UP Board of Madrasas Education Act 2004, calling it an infringement of the fundamental rights guaranteed under the Constitution. The top court also found the High Court's ruling to be against the principle of secularism. The decision gave massive relief to around 17 lakh students of the state's 16,000 recognized madrasas. What happened? Earlier, the High Court had dubbed the UP Board of Madrasa Education Act unconstitutional and asked for immediate closure of the madrasas. It called for the relocation and integration of the madrasa students with regular schools. The Supreme Court called the High Court's ruling not warranted. The Supreme Court called the High Court's ruling not warranted and imposed a stay on the relocation. The three-judge Supreme Court bench, headed by Chief Justice D.Y. Chandrachud, scrutinized the provisions of the Act and made it clear that the object and purpose of the statutory board which is constituted under the Act is regulatory in nature. The Apex Court did not agree with the High Court's ruling on educational institutions funded by state being prohibited from imparting religious instruction. The bench cited a 2002 judgment clarifying the term religious instruction. The judges felt that striking down the 2004 Act was not the solution towards making a provision for secular education alongside religious instructions. Why are the madrasas in the spotlight? Uttar Pradesh has around 25,000 madrasas, of which 1600 are recognized by the UP Madrasa Education Board. Only 560 madrasas receive grants from the government, though there have been complaints in recent years of delayed payment and arrears in salaries. The irregular madrasas are usually strapped for resources and manage to provide only elementary learning. The latest case in the Supreme Court is in continuation of a long trail of madrasas being the focus of attention. In 2022, the UP government ordered a survey of states' madrasas to find out the number of unrecognized or illegal madrasa. Though the findings of the complete survey were not made public, the state government caused a ripple in Muslim education circles when in October 2023, irregular madrasas operating in the western UP township of Muzaffarnagar were ordered to be closed within 24 hours. The Basic Education Department issued a notice to these educational institutions stating that the unregistered madrasas operating in Muzaffarnagar would be subject to a daily penalty of rupees 10,000 if they were not able to submit relevant documents within 3 days of the notice. The move upset my the move upset minority organizations with the Jamiyat Ulema Hind calling the move discriminatory. These madrasas provide free education to around 10,000 students. They will not have the resources to pay the fine. The order seems targeted at a particular community, a Jamiyat official had then said. Around the same time, a special investigation team was formed to investigate the sources of madrasas alleged foreign funding. The SIT claimed that the madrasas had received over 100 crore from abroad over the past 3 years, though evidence was not shared with the public. What next? Madrasas have been under the spotlight since the Yogi Adityanath government was first shown in 2017. At the time, the government had instructed madrasas to hoist the national flag and sing the national anthem on Independence Day. The circular issued by UP Madrasa Shiksha Parishad also asked these schools to videograph and photograph the Independence Day function as evidence. The order upset many madrasas who claimed it called into question their patriotism. Meanwhile, the Supreme Court bench of the UP Board Madrasa Education Act case has asked the state to file its counter affidavit before May 31. It has also given the appellants time till June 30 to respond of the state's views. It will hear the arguments in the second week of July.